So, good morning, welcome, Barton. Thank you so much for again be with us today. And just like every time that we open Barton Estro, it's oh my god, I have to work in my accent definitely. Living in Miami is not helping me at all. So, like I swear to God. So Barton is a real estate attorney, and he owns partner at Stroke Cohen and Zipper Law Group, also Safe Key Title and Closings, and Florida Supreme Court certified civil and county court mediator. Welcome back.
Thank you. I'll translate that. So I'm Bart Strock. I have been an attorney in Florida for over 40 years. We practice exclusively real estate law. I'm one of the owners of Safe Key Title and Closings, and also one of the partners in Strock and Cohen Zipper Law Group, which does business now as SCZ Real Estate Law. I am
Oh,
also a certified, Supreme Court certified circuit civil and county court mediator, and I do mediations that are restricted to real property cases. So, whenever there are disputes under the real estate contract, either pre suit mediation in a lease or a contract, I'm available for those. That's
you are.
what I do.
Yeah, you do a lot. You definitely do a lot, and always available for any agent or client that needs something for you. You always answer your message and your emails. For me, that it's amazing. It is no time that I send you an email that you don't answer. Thank you so much.
I try my
So
best.
yeah, you do. So we are talking today about evictions. And what is an eviction? Let's begin for that.
So, evictions are a very technical area of the law. There are some very technical areas like medical malpractice, antitrust. All of those areas are very technical, statutory, um, but so is an eviction. I mean, we have the Florida residential landlord tenant law, which is very specific as to the amount of time you need to give notice for everything and how that notice is provided. Most so our firm handles evictions. 95% of our cases are on behalf of the landlord. But if there's a tenant that has a real issue, not just trying to stay in the property and not pay rent, we will consider taking a tenant's case. So most of the problems I find when a case comes to me, if it's already been filed, is the person who filed the case made a lot of mistakes. They didn't give the right notice. They didn't prepare their complaint correctly. And half the time, it's realtors or property managers who thought they could do it all. But we all know about how much legal advice and what legal action a property manager or a realtor should be taking. The law has been the same for many, many years. Last year, for the first time in a long time, we had a substantial change to the law. One area. So for years, it used to be that you had to give 15 days notice to terminate a month to month tenancy. And then during that quote housing crisis, Miami-Dade, Broward, and Palm Beach County, and a few others adopted emergency ordinances that said you had to give, for the most part, 60 days notice, and there was some slight variations between the counties. Effective July 1st of 2023, the legislature preempted the counties or cities from making any changes to the notice statute. But in a compromise, they set the notice statute at 30 days. So now you must give 30 days notice of a termination of a month to month tenancy. So that's 30 days notice prior to the end of a term. So if someone's paying rent on the first of each month, then you have to give notice 30 days before the first of the month. If someone's paying rent on the 15th of the month, then you have to give 30 days notice before the 15th of the month. You can give longer, but you can't give less. Okay? Um, and
And
that's
it's
important.
when you have a contract that it's coming to end, and the landlord
Okay,
doesn't know what.
that's my next answer. So evictions, a good part, not going to say most, but a majority of the evictions are based on non-payment of rent. That is where the landlord gives a 3-day notice for payment, non-payment. Tenant doesn't get out, and you file a non-payment. Um, the next biggest area or topic for evictions is either a month-to-month tenancy where you've given a 30 days notice to terminate,
Mhm.
so they then become a holdover, or the end of a lease. When a
Mhm.
lease expires and the tenant doesn't move out, then they become a holdover tenant, just like a month-to-month tenant. And so there is so on a month-to-month, you're required to give notice, that 30-day notice.
Mhm.
At an end of a lease, you are not required to give notice because the lease has expired and you could just file the next day.
Okay.
I think it's fairer, it's nicer, it sits better before a judge when you send a courtesy notice. There
Mhm.
is no notice requirement in Florida, either under the standard form lease or under the statutes, that you have to give notice that the lease is not being renewed. Unless it's a lease that someone has written that contains that language. Some of the apartment complexes have that. Some have automatic renewal if you don't give a notice 60 days prior.
Mhm.
And some say you have to give 60 days notice to terminate. Um, but if you use the standard Florida form leases approved by the Supreme Court for realtors,
Okay.
um, there is no requirement for notice. Okay, what I always recommend is after you collect the last month's rent, if it's not paid in advance, uh,
Mhm.
then you send a courtesy notice saying this is just a reminder that your lease expires on March 31st and you're required to vacate the property by the end of March 31st and leave it in broom clean condition. Please make arrangements for a walkthrough, and your deposit will be handled according to section 83.49 of the statutes. That's a courtesy notice, okay? Not
Mhm.
required, but certainly helps start that communication.
Yeah.
Um,
So
the
the
the issue with that holdover, either at the end of the termination of a month-to-month
Mhm.
or the end of a lease, is if you accept a rent payment, you may be barred from going
month.
forward with an eviction. So if you accept a rent payment from a tenant whose lease is expired, they've now created a month-to-month tenancy. So then the next time you got to give a 30-day notice.
Okay.
So they're there for at least another 2-3 months. The problem we have today is that no one sends a check that you could send back. So
Yeah.
it's
Most of
done by
the.
Zelle,
Mhm.
and within a matter of a day or two or three, that money must either be um, returned to the tenant, refused, or sometimes it's the better practice to file the eviction and deposit the money in the registry of the court, notifying the tenant that it's been refused.
Okay.
So that's a big problem we're having now. I just had a landlord wait like 14 days to return the money, and the judge
Mhm.
said, that's too long a period of time. You held it, You
Yeah.
deprive them of it, and therefore they're now a month-to-month tenant.
Yeah, because most of the landlords wants the rent fast, and many of them are using sale to receive the um, monthly payments, and that it's basically money in their pocket when they make the transfer.
But if they're doing an eviction, then they should be consulting with their attorney
Mhm.
on how to handle that rent that's come in by sale.
The landlord can put themselves the notice of 3 days if they don't receive their payment on time.
The landlord what?
They can put the notice of the 3 days notice on the door that they require in the payment. The landlord can do that themselves, or they need
So
hire an attorney or a firm to do that.
a landlord could do a 3-day notice by themselves. What I find is they don't always prepare the 3-day notice correctly.
Mhm.
So the biggest mistake we see is the landlord includes items other than rent. They include a late fee. That cannot be in the 3-day notice. They
Uh-huh.
include the tenant's portion of the electricity or water bill if it's part of the lease. That's not. Only the base rent can be part of the 3-day notice. The second issue is how much time does the tenant have to respond? So
Mhm.
we know that a 3-day notice does not include Saturdays, Sundays, or holidays. It doesn't mean that if it ends on a Saturday, Sunday, or holiday, it goes over to the next day. It means you don't count them at all. So if I serve the notice on a Friday, I start counting on Monday as my first day. Monday, Tuesday, and Wednesday at midnight is the last time for them to pay. Holidays is even more difficult because it is not national holidays like as described in the uh, contract for purchase and sale, which specifically references federal holidays. The holidays in the landlord tenant statute are are the days when the clerk's office is closed in that county. So the clerk of court in Miami has a different holiday schedule than the clerk of court in Fort Lauderdale. And it changes each year and it's different throughout other counties. A clerk's office must be open so many days during the year.
Okay.
So some clerks, in order to give their employees off on the day after Thanksgiving, they open on President's Day.
Okay.
The clerks will do it on Columbus Day. So it's different in each county. And so, we have that list for almost every county. We check before we file a 3-day notice, but obviously, property managers and realtors and landlords themselves don't always do that. Now, the odds are you're not in a holiday period, so
Mhm.
you're okay. Um, but
So after the 3 days, let's see the tenant doesn't respond, doesn't they don't, let's see that they don't care. They stay on the property. What would be the next step for the landlord? They
so the
can.
next step is to file a lawsuit. So, for the landlord or the property manager, they have to, prepare the lawsuit, prepare the papers, go to the clerk's office, file it. What we do is if you tell us at 9 a.m. Tuesday morning that yesterday was the last date, of course, you have to send us the 3-day notice if we didn't send it. We
Mhm.
immediately prepare the complaint for eviction and we e-file it right online. It's usually filed within 2, 3, 4 hours. And then, depending upon the county, we get a summons issued and how that summons is served. So, again, there's differences in that. In Broward County, once the case is filed, we file an electronic summons. The clerk issues it. We email the summons and complaint to the process server who takes it out and serves it. In Miami-Dade County, we have to get the complaint filed first, we give that to the process server along with a blank summons, and they must take it to the clerk's office and get it issued. So again, it's different in every county. Palm Beach County, we don't even fill out a summons. It's actually filled out by the clerk based on the information we submitted. So they're all different.
Oh, well, definitely for me, rentals, for me, it's a very, not complicated, but it's a very delicate. I basically rent for the owners. I don't collect rents, and I don't like to be involved in anything that have to be with any type of management, because I don't do that. But I receive the phone call when they don't pay, and what we are doing now. And they said, like, we can go to the court. Myself, I just to the fact to don't understand all the steps that have to be done. I always said, like, it's better if an attorney does. I said, no, but I understand, I can do myself.
Let them.
So, well,
They only
yeah.
have to do it once or twice themselves, and then they'll learn the difference. So I could probably do it in half the amount of time. The costs are the same. I mean, I pass through the costs, and I think we charge now, the fee just went up a little. I think we charge like $750 or $795 for an uncontested eviction. But we're getting it done a lot quicker, and they're getting new rent a lot quicker.
And once it's, I have a question. Once it's a file on court, how long it takes for the court review the paperwork? A standard, no? It depends on the case,
There
obviously.
is no standard.
No
So
standard.
the so what I told you is first we have to file the case with the clerk. That could take anywhere from 2 hours to 2 days for it to
Okay.
be accepted. Sometimes the clerk drops the ball, it takes a little more. But I have a paralegal, Nina, who calls that clerk every day and follows up.
It's good.
Um, then the summons to be issued could take 20 minutes to 2 days. Then the process server has to serve it. Broward County, we get service within 24 hours, usually less. Miami-Dade County, we get, again, they have to go to the courthouse and pick up the summons, so it's another day or two. Then comes the big problem. What judge is the case assigned to? Which division? Every division has different procedures, okay? So let's say in Broward County, the tenant files an answer after they're served, 5 days after they're served. In Broward County, the clerk is going to send that answer up to the judge immediately. And the judge is going to either set a hearing, set mediation, or enter an order saying you have 5 days to deposit the rent in the court or a final judgment will be entered. Okay? In Miami-Dade County, it's different in every single division. We may get a hearing and, we have to call, when we get the answer, we have to call the judicial assistant. They have to check with the judge. We may get a hearing in 3 days. We may not get a hearing for 2 weeks. So to say what the normal procedure is, I can't tell you. I will tell you that up until the housing crisis, COVID, whatever, our average eviction was 45 to 60 days, but in most cases, the tenant vacated on their own once
Okay.
they were served with a summons. When COVID came and the moratoriums went into effect, and people learned from various agencies or online how to file an answer, more people started filing answers, which requires us to follow up quicker. And I would say now the average time is you just have less people automatically moving out.
Yeah.
They know they have until the sheriff posts the writ of possession. And again, 99% move out before the sheriff actually comes to evict. But we're looking at 45 to 60 days. Again, depending upon the county, depending upon what judicial division it's applied, it's assigned to.
And it's always the sheriff that goes to put the notice that they have to evacuate
That
the.
must be the sheriff.
Okay.
So the Miami-Dade County Police Department, once they get it, they take 20 days to even post it. Um, Broward is less.
Okay. And when it's an invasion that somebody just put their self inside the property because was vacant for a long time, what
That's a whole different. So they're not a tenant; they're a squatter.
the square? Uh-huh.
So that is not a landlord-tenant relationship. That comes instead of coming under Chapter 83 of the Florida statutes. That comes up under Chapter 82 of the Florida statutes, which is called unlawful detainer. That's an ancient word coming from the Old English common law, but that is for someone who enters the property legally or illegally and refuses to leave when demanded by the owner. So it's treated like an eviction. We have the same thing. You the 5-day summons, it's advanced on the calendar, but it is not an eviction. And a lot of people make the mistake is they file an eviction and the
They will
person is not a tenant. So that could be either, like you say, someone breaks in.
hmm
Sometimes we can get the police to throw them out, but not normally. Um, or it could happen. Um, my this is my famous case, but I have others. Um, my son came to live with me. I'm an 85-year-old woman. He's abusive, whatever, and he won't get out. He doesn't pay any rent. So he entered the property lawfully. There is no landlord tenant relationship.
hmm
And the only way I can get him out is to file an unlawful detainer. And he's got 5 days to answer and whatever.
Oh,
Or I let my granddaughter live there while she's going to the University of Miami. And then I want to sell the place and she won't get out because I'm not charging her rent. Yeah.
okay. Yeah, I hear about that, and also when relationships, the people that live together, and
Yeah.
then
And they won't get out.
said, "I'm not moving." So yeah, I hear a lot about that ones.
Yep.
And uh and for the evictions, for the landlord tenant, it's just when the tenant doesn't pay rent, or it's another evictions, another type of evictions.
There are other types of evictions. They don't happen that often, but enough. So if the tenant fails to materially comply with the terms of the lease, so the tenant's paying their rent, but they're not following the association's rules. So the landlord gets a letter from the association. The tenant's paying the rent, but they're also selling drugs out of the property, and the police have arrested them. They're still paying the rent.
Yeah.
Um, the tenant is paying the rent, but they're not taking in the garbage cans from the street on a single family resident, and now the owner is getting fines from code enforcement and things like that. So there you have to send a 7-day notice to cure. Okay. And if they don't cure within 7 days, then you start an eviction for material noncompliance. All the other rules, same apply. 5 days summons. There are certain that could be material noncompliance and non-curable. So if the association has sent a letter saying we want you out because you beat up the security guard or you're rude to everybody, that's a non-compliance that can't be cured once the association has terminated the lease. So there are certain things like that. Where you just send a 7-day notice saying you're out in 7 days. There's nothing you could do about it. We're going to file suit on day 8 unless you vacate. Um,
Interesting.
those are the only other types. Um,
I I barely use the contract, the lease contract for the far bar. Once because 18 pages, and I know nobody read it, and no, it's nobody read the contract, but 18 pages for a lease. It gets complicated for the tenants and the landlords. I don't have one landlord that said I read it and I understand everything. But
So, first of all, I think 11 pages are just the statute, which by
mhm,
law is required to be attached. Well, I don't expect any landlord or any layperson, non lawyer, to understand the statutes. They're written by lawyers for lawyers.
mhm,
And as I said, the Florida Residential Landlord Tenant Act is very, very technical on how to give notice and the number of days and the notice must be substantially in this form. You know, over and over and over, I see landlords violate that law as to returning deposits. They don't send it by certified mail. They don't give it in the form that says you have 15 days to object. They don't
mhm.
specify how much they're holding, and that's usually where I take a tenant case, um,
Okay,
because automatically I'm going to get the tenant their deposit back because the landlord failed to follow the notice provisions.
okay.
So, but as to the lease itself,
Mhm.
you know, the landlord is in a business. If he doesn't understand it, he should get a consultation with an attorney. You're not allowed to. The realtor is not allowed to explain the legal technicalities of the lease. Um, and so, if the landlord wants to understand the contract, he should get a consult with his attorney or an attorney to explain it.
Yeah, I really believe it is kind of necessary. I see more and more in both sides. I see more on the side that the tenant, for um, many reasons, not just because they lost their job or maybe sick or any other, maybe justified reasons to be late on the rent. But also, I see the properties getting a little damaged, to say so. And the landlords get a little upset about what we are doing now. So what is the next what I can do? So
Okay.
it gets
So
a
let
little.
me say something.
Mhm.
You say the person loses their job, so they have an excuse for not paying the rent.
No, no, it's
There's no excuse. You have a contract.
yeah. Mhm.
The landlord is in business. The landlord is selling a product. I don't want to sound like a hard ass. I understand things happen. But the landlord is selling a product. In this case, that product is so many square or cubic feet of a unit
Mhm.
they allow someone to buy on a month to month basis to live in. If that tenant lost their job, would they be allowed to not have the money and take or buy any other product? No, they couldn't go to Publix and say, listen, I need this can of green peas to feed my children, but I lost my job, so I'll try to pay it next month when I get my unemployment compensation or I apply for assistance or whatever. No, Publix is not going to let them take that product. And therefore, the landlord, there is no excuse because the landlord's got to pay association dues, taxes, insurance, all of their overhead, just like Publix does, including their realtor, maybe, who's a property manager. So it doesn't work like that.
No,
So
I don't say
my
it is an excuse.
recommendation is if the landlord wants to be a nice guy, you
Mhm.
serve the 3-day notice and then you negotiate and then you discuss. Because then the law provides for you to put in a payment schedule as short as possible and not have to serve another 3-day notice if the tenant doesn't pay. Okay?
Yeah. If the tenant agree, and and by the way, I'm not excused. I'm telling. I try to say that if they have a conversation and he's late, no, no payment. It's late, so no, no payment. I don't say that it's an excuse to don't pay. Not at all.
I understand, but I have to have these discussions with
Yeah.
landlords all the time. and tell them, because they come to me and say, okay, now they owe me 4 months rent. I also want to collect that. I said they couldn't pay the 4 months now. They
Mhm.
allegedly don't have a job. A tenant is a tenant because they don't have the down payment to buy a house. Where do you think you're going to get that money from? Why waste money to sue them for a judgment you will never collect?
Yeah, correct.
You're never
Exactly.
going to make up that money.
And if that is the case, and they have, let's see, the last month and the security deposit, the landlord also have to send the certified mail that said that they will be using the security deposit, or that's never like a choice to get collect any rent.
Okay, so the landlord can't take, so that the security deposit and the last month's rent must be held in a separate non-interest bearing account, and not the account where the tenant is paying rent to, because then you're commingling the landlord's funds and the tenant's funds.
Hmm.
It must be in a separate account, not where rent is being paid into. And the landlord can't take the last month's rent until the first day of the last month of the lease, even if the tenant is not paying, unless the tenant specifically authorizes it in writing. The landlord cannot take the security deposit, because what good is that then? Because what if then they have to evict the tenant and there's damage? So
Hmm.
you don't wait. You file the eviction and then we negotiate afterwards. Okay. But I never allow the security deposit to be used for last month's rent.
Yeah, I saw that when they call and I said like they have 2 months. They don't have 2 months. They have the last month and they have the security, and you cannot touch the security until they leave the house because you don't know the conditions the property will be after they move
And
out.
unless you have an addendum to the lease that says I'm allowing you to terminate the lease, so this is going to be the last month, you can't touch the last month's rent.
See, that's the reason you have to be in the middle.
I know my landlord tenant law.
And I have to say it's taken in very slight way, because like I said, it is a lot of details in that contract and on the law that it is not well known if you don't work on uh, with tenants and landlords all the time and
Hmm.
be involved in this. And that is the reason I don't like. I am very careful with the tenants, because I really know it can be very complicated, and when evictions coming on, it's really get a little hard to get into the court, and then the police and the families and all that. It's a situation that it is not happy for the landlord, neither for the people involved to do the evictions. So
Anything else?
no, that's it. Thank you so much as usual. You go far away for what I said. What I said that I will be talking, and I always give you a run to give me more information. So thank you so much. I hope you have an amazing day, and see you next week.
All right. So anybody who needs help in landlord tenant law, closings, or anything else, you can reach me at bstrock@strocklaw.com, or my phone number I think is up there somewhere.
Yeah, it's on the bar that said
Hmm.
your phone
And
number.
thank you, Jackie, for providing everybody with such information that helps them get through the day of life. Okay.
Thank you so much.
Okay. Bye bye, everybody.